everyone, and welcome to Tax Tips and Tricks for the Family Law Practitioner. Thank you for joining us this evening. My name is Carrie Holmes. I'm the Pro Bono Director at the Harriet Buhey Center for Family Law, along with my co-chair, Ron Reichstein of Young & Reichstein. We thank you for joining us. Thanks also to the tax section for co-sponsoring tonight's program. Please make sure to tune in on June 23rd at 5:30 p.m. for Beyond Cryptocurrency, a family law primer on NFTs and other digital assets, featuring speakers Ariel Leichter-Morocco, founding partner of Leichter-Morocco, and Mike Dudas of Paxos, a regulated blockchain and crypto infrastructure platform. If everything I just said sounds like a foreign language to you, please make sure to attend. A link to the materials is going to be posted in the chat. You'll receive your MCLE certificate shortly after the program ends. After the program, please take a moment to complete the survey, and a survey link is going to be included with your MCLE certificate.
Family Law section in all of its programs is sponsored by SoberLink. SoberLink system combines a portable breathalyzer with wireless technology, trusted for use in child custody cases since 2011. They are the only system that combines court admissibility in all 50 states and Canada, facial recognition and tamper detection, real-time results, easy-to-read advanced reporting. Trust the experts in remote alcohol monitoring technology for your custody cases involving alcohol. White, Zuckerman, Warsofsky, Luna, and Hunt. White, Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. You're invited to contact them to discuss your specific accounting needs and learn how they can be of service to you. Our Family Wizard. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, checking out exchanges, send messages, and more, all while thoroughly documenting their activity. Hochman, Salkin, Toscher, Perez, PC. Hochman, Salkin, Toscher, Perez, PC Advantage is experience in an eye for innovation and a genuine dedication to clients, their families, and their businesses. In addition to their national practice in civil tax and criminal tax controversies and related litigation in federal and state courts, the firm is also active and successful in handling non-tax matters, such as business and estate planning for high net worth individuals and closely held businesses, together with white-collar defense and commercial disputes. With that, I'll hand things over to Alex Greger, who has done a wonderful job organizing tonight's event, along with Igor Drabkin and Jennifer Magnus. Thank you all for your time.
Good evening. Thank you for joining us. My understanding is there are about 125 people watching, so there is no pressure on the presenters at all. My favorite part thus far was Ron Reichstein reading the commercials. I thought it was awesome. I'm Alex Greger. I am a partner at Feinberg Mindell Brandt & Klein LLP on the west side of Los Angeles, and presenting with me today is Igor Drabkin, a partner at Holtz, Slavitt, and Drabkin, tax attorneys, and Jennifer Magnus, CPA, a partner at, I'm going to screw this up, White, Zuckerman, Warsofsky, Luna, Wolf, and Hunt, or is that the old name? I don't know. Old name. I don't know the name. At the White Zuckerman firm, whom we all know and respect. Tonight's program is on tax issues in family law. It's a big, broad topic, and what we try to do, obviously, we only have 1 hour, so what we try to do is do the highlights of just the issues that may be relevant to the family law practitioner, both from the perspective of tax controversy and enforcement issues that clients ask us about, signing tax returns, tax liabilities, and the like, and also from the perspective of tax considerations when it comes to dividing marital assets and when it comes to income and support issues. We will try to answer questions as best we can. If the participants would please put their questions in the chat, I will try to keep an eye on it, and we'll try to get to them either during the program or at the end. Hopefully, we will have some time. We start with a conversation about just generally what a family law practitioner needs to know about taxes. Because when we say taxes, obviously, we mean a lot of different things, and there are different types of taxes. So Igor, perhaps you can start us off and talk to us about just maybe different types of taxes that family law clients should be aware of, and perhaps just generally the way the tax system works.
Thank you, Alex. And as a brief introduction of myself, kind of getting into the topic, I'm a former IRS attorney, and I spent about 6.5 years with the IRS as a tax litigator. And I've been in private practice for about 14 years now, representing taxpayers who have disputes or problems or potential problems with the IRS or state tax authorities. So I'll try to focus my side of the presentation on what potential tax problems family law practitioners may see, how to deal with them, how to address them, how to work them through the IRS or state tax agencies. And I'll leave complicated tax questions for Jennifer. What kind of tax issues can we see in a family law case? What kind of problems? Well, there are several types of taxes. The most common one is income tax that we all deal with. And this is the primary issue that arises, at least from my perspective and my experience in family law cases, where two people separate, go through the divorce proceeding, they file joint tax returns. Sometimes they underpay their liability. So let's say they filed the tax return a year before they filed for divorce. They couldn't pay the tax on the return. And now there's a joint tax liability that will affect both spouses who are going through the divorce. Another potential issue is if, let's say, two individuals going through the divorce or got divorced, but the IRS has a certain number of years to examine their income tax returns and propose any changes or adjustments. So what happens if two people are divorced, but now they're going through the audit of their joint income tax return? There are issues that may involve employment taxes. For example, a family can own a business, or one of the spouses is running the business, and this business may have cash flow issues, and let's say, for argument's sake, they're not paying their employment taxes. What happens with this tax liability? With employment tax liabilities, the IRS and the EDD can go after responsible individuals. Is it one of the spouses? Is it both of the spouses? Are both of the spouses listed on as officers of the corporation, for example? Who is responsible for the tax liability assessed against the business? Similar issues may arise with sales taxes. If the business is run in California Department of Tax and Fee Administration, formerly known as Board of Equalization, can go after responsible individuals for failure to collect sales taxes. There are myriad of penalties involving, let's say, foreign assets and offshore income. Who is responsible to that? So that's just a brief example of the issues that I think people going through divorce or that just got through the divorce may see, and this tax issues may affect them even post-divorce.
So in our business, right, tend to call them in-spouse, out-spouse. So it happens all the time, right? That a client would come into our office and they would say, for the past 20 years, I was signing joint returns with my husband, but honestly, I was just signing what was presented to me. My spouse has been in charge of the family finances. He runs the business, he runs the dental practice or whatever it may be, and I've been signing the returns. So I guess the dual question is, when a client comes to us and says, well, should I still do that? Can I still sign the return? What is the advice? What is their impunity or what is their punishment? And related to that, the question is, perhaps for both Igor and Jennifer, is, as a general matter, what should a client know about the finances or about the nature of the tax return before signing? Should that spouse immediately get their own CPA and verify the information on the jointly filed return, or is it okay?
Well, I think we need to begin with two premises that are important to remember. One is if a tax return, an income tax return, is a joint return, then both taxpayers are liable for any deficiency or underpayment on the return. From the IRS standpoint, this is joint and several liability, and they can collect from either spouse. So that's a presumption that the IRS will operate from. Both spouses are liable for the tax liability on the joint income tax return. The second concept that I'm sure all the family law practitioners know better than I do is the community property aspect. In community property states, the IRS can go after community property even for separate debts of one spouse. So even if there is a separate tax liability, let's say either before marriage, or let's say it's a trust fund recovery penalty on employment tax assessed against one spouse, our community assets in play here from the collection standpoint. Jennifer, do you have any?
Yeah, I was going to say, Jennifer,
Yeah.
add to that, like, does the source of the income reported on the return affect the division? And I understand from Igor, that's not binding on the IRS, but.
So I think when we have clients coming to us and they're entering this process and they have no idea about the finances, we always say first and foremost, if you're provided a tax return, they should have their own tax accountant review it and see if they feel comfortable with it. But certainly if they think that there's some funny business going on with their spouse's business, that they're hiding assets, hiding income, they may not want to be joint and several on this tax return. They may want to file separately, and no one can force them to do that. But we always have to remind them, as Igor said, we are in a community property state, and they would be responsible to report 50% of the community income if they file separately. So it's something that they really have to weigh the pros and the cons of filing separately. A lot of times we do see indemnification agreements. And, I know, and I'm sure Igor can talk about that even more, is that the IRS doesn't care about that indemnification agreement, but at least they would have that for family court to use to get reimbursed if the IRS does come after that outspouse who doesn't really know anything about what's happening. And that is something always to keep in mind, is that when people are getting divorced, if they want to file separately, they're going to have to report 50% of that community income. And it's not a difficult process, but then they have to work together to make sure that the tax returns mirror each other. So there is one more step involved in that.
And so are there any consequences for non-cooperation? Because I guess in most cases, we hear that by signing a joint return, the spouses will save, $20,000 in taxes. And then I would hear from my opposing counsel something. And so if your client does not agree to sign the joint return, we'll assert some sort of a breach. But I think what I just heard you say is there's absolutely no obligation to sign a joint return. But then the related question is, I think you said, Jennifer, the outspouse still has to report 1/2 of that community income, right?
Yes.
But in a lot of our cases, of course, there is adversity, and one spouse does not necessarily know what the other spouse is reporting on their return. So is there a best practice there? And then I'll turn to Igor for some just back-end questions on collections and enforcement.
Yeah, I mean, I think it's a difficult situation to be in, whether to file jointly and get that indemnification and really hang your hat on that, or to file separately. I do have one case right now, and our tax partner advised to file with as much as you know, with a footnote to the IRS that this is probably going to have to be amended once they get the rest of the information. So there's that alternative to make it known this is all you know about at the moment. But again, that's extra cost to have to amend at a later date. So, you know, there's alternatives, but you got to weigh your pros and cons.
Right. And
this issue of community property split reporting income 50-50 if you're filing married, file it separate is an interesting thing, because I'm sure Jennifer and her firm and reputable accounting firms do it absolutely right. But in my practice, I see all the time that it's not done right. Basically, each spouse just reports his or her share of income without splitting it 50-50 under the community property rules. And to be honest with you, from my experience dealing with the IRS, this issue is examined very rarely, if ever.
Okay, so that's actually a perfect segue into the next question I wanted to ask, because you know how when you talk to a criminal defense lawyer, well, not we, other people always ask them, how do you get out of a DUI? So, you know, with you, Igor, you know, our clients, and I'm sure some of the attendees of this program want to know what triggers an audit. You just said that something like this would trigger it rarely, but, you know, people talk about incompatible filing statuses, incompatible reporting. Maybe you could talk a little bit about, on the one hand, what would trigger an audit, and on the other hand, like what actually happens? What actually happens when the IRS gets interested in you?
Sure. There are some easy triggers that can generate an audit. Most of them are just computer-based, based on processing of the tax returns. For example, again, if two spouses are filing separate and claiming the same child as a dependent, they may flag it for an audit. Easiest things that will trigger some examination is if someone is missing a W-2 or a 1099 that was filed under the Social Security number. So again, this is just computer-generated type of audits where something in the tax return does not match the information received by the IRS from other sources. Other types of an audit are more difficult to predict because they are based on various data analysis by the IRS. But obviously, there are returns that are more prone to an audit or less prone to an audit. So, a tax return with W-2s and nothing else is probably very unlikely to get audited unless something doesn't match. This is easy to verify. Obviously, returns with Schedule C that report sole proprietorship business, returns with income from S corporations, partnerships, LLCs, basically those entities that self-report their gross receipts are scrutinized a little bit more. It depends on the total income. It depends on the total expenses, right? The IRS is good at analyzing the data, right? So for example, for any given business or for any given industry, they have a data of what, let's say, the average or the mean of, or the window of gross receipts and expenses is. If a given tax return is outside of this normal parameters, it's more likely to get audited. Although I must say that overall, the current status of the audit is where there is less than 1% of individual tax returns being audited. I think we're going to see a change in that from everything that we are hearing in the news with the budget, Both parties seem to agree that they need to fund the IRS more. So we probably will see a turn in that and more enforcement. So probably we'll see more audits, more examinations, more collection efforts from the government.
Okay. Jennifer, anything to add to that? What about the different filing statuses? At which point there's a lot of confusion about, obviously married people can file married filing separately, but I know there is a lot of confusion about when a person can file as head of household, when a person can file a single, and also is there any correlation? Do the two filing statuses have to match or it doesn't matter? Can you talk about that?
Well, the obviously married filing joint, I think we all know what that would mean, and married filing separate as well. In order to qualify for head of household, they would need to be living separate and apart for 6 months of the year and obviously have a dependent. So they both have to be met for that to be able to be used. So a lot of times we will see a married filing separate and a head of household. They cannot claim single status until they are officially divorced. And it all falls under what happens at December 31 of the year. So if they're divorced by the end of the year, they can claim single status.
Okay.
Yes, this is the basic rule that seems to avoid a lot of people. The filing status is based on your married status on the last day of the tax year. That's it.
But married people can still file a head of household. They can still be married, and that seems to be triggered more off of a residency requirement, so to speak, as opposed to their actual marital status. Okay. Okay, let's talk about innocent spouse. That seems to be the next topic in my list. And I should have mentioned this earlier, but the program materials, the link rather to the program materials is found in the chat for those of you who want to download them, and those are primarily provided by Igor, so we thank him for that. Igor, talk to us about the innocent spouse. What is innocent spouse? Who can claim innocent spouse? And sort of most importantly, does it work?
Yeah, I'll begin a little bit earlier with your earlier question, what to do if the IRS, let's say, audits you, or what if something happens? So once the IRS initiates an examination, it reviews the tax return. The case is assigned to the examination function of the IRS. There is a revenue agent assigned. They review this, and let's say in the end of the audit, they propose a tax liability. It may be a tax liability attributable to additional income. It may be a tax liability attributable to disallowed expenses, or combination thereof, or some other issues. So again, if it's a joint return, there will be joint tax liability unless one of the spouses decides to claim what is known as innocent spouse relief. Innocent spouse relief is a term which is governed by Internal Revenue Code section 6015. Basically, it talks about separate liability that one of the spouses can claim or request with respect to the joint liability asserted by the IRS, either through the audit and a deficiency, or through underpayment of taxes. Again, we see a lot of situations where individuals file tax returns that is not paid in full when filed, and it creates a tax liability that is assessed against both spouses, and then the IRS is trying to collect from both spouses. So when can someone claim an innocent spouse relief?
And what do they need to show?
Yes. Well, they need to file a specific form. It's called Form 8857. Let me try. I know we attached the materials, but maybe I'll share the slide. So innocent spouse relief can be claimed by the requesting spouse filing Form 8857. It must be filed within 2 years from the time that the IRS has begun collection activity against the innocent spouse. So what does it mean? And why it's important to be aware of the IRS notices that sometimes people discard. And that's why it's important to keep your address current with the IRS. So once the IRS issued a notice to the spouse, basically sending a bill saying you owe us an X amount, the taxpayer has 2 years from that date to request innocent spouse relief. So innocent spouse relief can be claimed in a deficiency case, again, when the IRS is proposing a tax liability and issues a notice of deficiency. For example, just a month ago or so, I filed a tax court petition claiming innocent spouse relief for my client who's been divorced from her ex-husband for many years, but the liability stems out of the IRS pursuing him post-criminal tax conviction. And again, because that particular tax year was filed jointly, the IRS is issuing this notice of deficiency to both spouses, and we are raising this defense in the so-called deficiency procedure, where the deficiency is still being established by the courts. The taxpayer can also claim this as as a defense to the collection notice in a collection due process case. So again, just everyone should be mindful that the notice is being issued when the notice is being issued by the IRS, and then make sure that the statute of limitation is met. It has to be within 2 years, unless the taxpayer qualifies for equitable relief that we can talk about a little bit later. But basically, this code section 6015C allows the taxpayer to claim relief from joint liability if they are no longer married or separated or not a member of the same household for the last 12 months. The IRS, unless any transfer of assets has happened as a part of a fraudulent scheme, and under this particular section, the relief is not available if the IRS can prove that the taxpayer who is claiming the relief had actual knowledge of any items giving rise to the deficiency. So again, let's say if the taxpayer claiming the relief knew of the unreported income, they would not be entitled to such relief. Frequently, the taxpayers go through the so-called equitable relief, which is a subsection of 6015, 6015F that tells us about the requirements for again, it's joint return. There must be a timely claim made. There got to be no fraudulent transfer. If the taxpayer does not qualify for 6015B, I may not have mentioned it. Basically, 1615B is a split of the liability where the IRS will attribute each spouse's income to him or her, and thus will split the tax attributable only to each spouse's taxable income. So under the equitable relief, if no other sections work, the taxpayer can pursue it. You got to show a bunch of equitable factors and convince either the IRS or the courts that it would be unequitable to hold the taxpayer jointly liable for the obligation. So I think the most important factor in innocent spouse relief is this kind of knowledge, or under equitable relief, a reason to know of the payment on understatement on the return. What is the reason to know? Because every client that we had said, I did not know that, let's say, my husband did not report all the income. Well, the IRS and the courts go beyond that in the analysis. For example, if the taxpayer signs the return and she sees that, let's say the joint return reports $200,000 of gross income, but she knows that their expenses are much higher than that, right? The lifestyle is higher than that. The IRS will argue that this was a sufficient reason to know of the under reporting of income, and will try to deny this relief. So all this kind of equitable factors become very important. I think we don't want to make this program completely on innocent spouse relief, but this slide is, I think, a good summary of what section is available for the requesting spouses. One more practical point, I think, is that even though the IRS, or let's say agreement within the divorce case or stipulation is not binding on the IRS, I think it still can become a very important factor in us arguing for innocent spouse relief. The IRS will not just accept the determination that, let's say, one spouse takes the responsibility, but if the stipulation agreement uses specific terms and discusses whether the spouse signed the returns knowledgeably or not, whether she had an opportunity to review the returns or not, whether one spouse, let's say, had a secret bank account or something like that. So that's where we can work with family law practitioners in entering certain language into the stipulation that can be useful later on in arguing for innocent spouse relief.
That's a good tip. That's something you should know when we are drafting our stipulating judgments and we're drafting our releases and indemnifications. Probably a good idea to check with the tax lawyer if we expect that these issues will arise based on the parties' jointly filed returns. Igor, you want to stop your screen share for a second?
Yes, that's what I'm trying to do right now. Hold on.
No problem. We will switch gears and let's talk about the issues that are near and dear to our hearts, which is dividing various assets during the divorce and the tax considerations of those divisions. So, Jennifer, let's start with something simple, I guess, which is some of my clients get very surprised when I tell them that if they take the house in the divorce, once they sell that house down the line, they will be responsible for taxes. And the question that I get a lot is, but hold on a second. I thought that the assets that are divided in a divorce are not subject to taxation. So I understand that that's mixing apples and oranges, but maybe you can explain that a little bit.
Yeah, I mean, we all know, right, if something's not immediate and specific, the court is not going to consider it when doing division. And so if the house is not being sold through the divorce, those taxes and sales fees and costs and everything else that's associated with the sale is not also going to be considered in terms of that. So I always say to my clients, what are your short-term goals? What are your long-term goals? Are you planning to stay in this house for a long time? Because if you plan to sell it in the next year or two, it's not going to be worth it for you. Things to consider are, if you're selling the property and let's say it's the residence as a married couple, or even after your divorce, but your residence, there's that $500,000 of exemption of a gain that you get to share to reduce your tax liability. And the second that property gets awarded just to one spouse, and then even if they sold it, just 6 months later, it's now only theirs. They only get the $250,000 to take against the gain. The taxpayer is going to take the tax basis with them, the entirety of it. And so if it's got a very low tax base, they're responsible for those gains. They're responsible for the fees and costs of sale. So if they plan on staying in the property long term, sure, that might make some sense for them. And if they can afford it, that could be a really great deal for them. But if it's something that they really only thought they would stay in a couple more years, maybe till the kids graduate high school, and they've only got, 2 more years left, it may not be a financially sound decision for them to make.
Understood. And what about retirement accounts? Because typically in a divorce, we do not equalize retirement assets against non-retirement assets, because retirement assets are not cash and it's not money now, and because a lot of them are taxable. So
yeah, I think
it's too simplistic to say the house has $300,000 in equity. There is a $300,000 community 401k. Why don't I take the house and you take the 401k?
Right. So when it comes to retirement accounts, most of the retirement accounts, and we're not talking about your Roth IRAs, but your 401ks and your regular retirement accounts are going to have a $0 tax base. So every single dollar that's within those accounts are pre-tax dollars. And then to get them out of the account, you have to be a certain age or you have to meet certain requirements to not be incurring penalties. And I think most judges, most that I've seen, and most attorneys will try to keep those assets as separate as they can from everything else and just equalize the community using those specific assets. And even to take it a step further, because there are Roth IRAs versus a regular IRA versus your 401k, everything has a different perhaps tax basis to it. So you should really try to, if possible, equalize like-kind retirement together. So the regular IRAs with the 401ks together, and maybe your Roths, if there's more than one, can be equalized against one another. But even then, they could have completely different tax basis. So you want to be very careful with the retirement accounts.
What about other types of investment accounts? We hear the term divide in kind a lot.
Yes. So if it's just a regular investment account, I think it's really important that when you go to divide the community, while there is a tax consequence in those accounts, every stock, every bond, every security is going to have a different tax base. So you're not really going to know unless you sit down with their financial advisor, or you go through every single asset to know what the tax consequences of each asset is. So the tax consequences are generally not taken into account during the division process. And by that, I mean figuring out, who's getting what and what the equalization payment is. But let's say, for example, an account, the community portion is just being divided equally by the parties. It would be very important and very good and smart to make sure that every block of stock is divided equally. And I say that because rather than sticking a specific dollar amount on things, there could be stock A worth $100 a share and stock B worth $100 a share. And so you say, okay, well, if they each get the same amount of shares of each of those stocks, then they've equalized. But if stock A had a really low basis and stock B had a really high basis, they're not really coming out with the same after-tax dollars. So I always, again, as much as possible, if we can, to say that Schwab account you have has, $80,000 of community in these specific stocks, and those are the ones that should be divided. I think this is also really important for accounts where you've got someone tracing separate property from prior to marriage, because those premarital stocks probably have a very low tax basis when you're comparing with the community stocks that were bought much later in time. So rather than sticking a specific dollar amount, you may want to identify which community stocks need to be divided to make sure that the party that's getting those community shares is actually receiving what they should get.
Okay. Igor, anything to add to division of assets? I know this is not necessarily your area.
Sure, I think
I guess it may relate to how people report these things in their tax returns.
I would say the only thing, double check, especially with real estate, whether there is any tax lien filed against any assets or against an ex-spouse. Again, remember, there may be a tax liability arising before marriage or assessed separately against the ex-spouse. If the IRS has filed a lien against the community home, this lien will continue to attach to the house until the liability is satisfied.
All right. And so let me go back to you for a second on that. So you just mentioned a pre-marriage tax liability. So the IRS can impair the community, so the other spouse's share of the community property in a home. So let's say it's a
Yes.
$100,000 tax lien, and there's
Well, I think like any other creditor, the IRS can collect from community property on separate debts of one spouse. So let's say it's year 2010, the taxpayer incurs a tax liability on a single tax return. The next year, she gets married. They start filing jointly. They purchase a house as a community property, as a community asset. They both pay for this house. In 2014, 3 years later, after the IRS cannot collect on the debt, they file a notice of federal tax lien against the taxpayer wife. Now the community asset is impaired.
Sure, but I think the difference from any other creditor is, I think you just said that the lien follows the house. So in other words, right, a regular creditor, a bank, right, probably cannot collect from an account of a spouse after that account has already been divided. And you were saying that in this case, the lien attaches to the asset and it follows the asset, despite the fact that it has been divided in a divorce. The spouse that moved out received some consideration for it, and yet
Right.
the lien
But I think
follows
yes,
the pre-divorce nature of the asset.
Yes, the tax lien attaches to all the assets of the taxpayer. So with notice of federal tax lien, I think at least there is a way to see it and maybe plan for it in the divorce case. I don't know whether Jennifer has seen the issues like this in her practice, or you, Alex, or some other family law practitioners, but I would be mindful of potential tax liens filed.
Okay, thank you. And Jennifer, let's talk about something that is a little more complicated, at least in my practice, and that is the treatment of stock options and the RSUs, which in itself is a big topic, so we will not be able to dive too deeply into it. But can you talk a little bit about stock options and the RSUs, I guess, both as they relate to division of assets and how they're treated as income, because then we can dive into a little bit more of income issues.
Yeah, I mean, these are very interesting for us because they are both, right? They are an asset. They vest over time. So the ones that have been granted during marriage are going to have a community portion and a separate portion. So when the estate is getting divided, those community units that have vested, or even the ones that are unvested, need to be divided. And I always have the question asked of me, well, how do we do that? Because they can't be transferred. So oftentimes the employee spouse is holding them in trust for the out spouse. And they have to give notice and everything else. But of course, when those units become income, when they are exercised or sold or what have you, the employee spouse now has everything and they have to provide it to the out spouse. So the first question I'm always asked is, what do we do about the taxes? And if it's during the pendency of the divorce and, they're filing separate tax returns, let's say, obviously, if they're joint, it's a little less of an issue. But if they're filing separately, there's always the form that's called Form 8958, which allocates income between the spouses. That's community. And so you would take the community share income and you would allocate it to each spouse on that form. And that way each spouse is paying taxes on their share of the community shares and getting credit for any taxes withheld from those shares, because that would have been their community share of tax withholdings. And so all of that information needs to be provided to the out spouse. Of course, those amounts, of course, need to be provided to the out spouse as well through a transfer of some sort. But there is a way to report that when they're filing married, filing separately. Now, once the division happens through the judgment and the stocks are awarded to the out spouse, but they're being held in trust, they're no longer filing a married, filing separately. There was actually a revenue ruling that said that although these are going to show up on the employee spouse's W-2 and he's got to pay payroll taxes, that income can be assigned to the out spouse, and the employee spouse would not have to report that income on their tax return, but the outspouse would report their share. So there is a way for the both parties to be reporting their fair share on their own separate tax returns, even as the outspouse. And now this revenue ruling refers to non-qualified options and not, ISOs and other things. So there's all different nuances to it, but they can all basically be applied the same way. And like you said, Alex, we could spend an hour talking about stock options. There's a lot of information about that. But I think the big takeaway is that the community shares need to be divided. They can be divided equally, and each party is responsible for their share of the income and the tax withholdings.
And at which point do they get divided?
Well, I mean, that's going to depend, right? Some of the employers will allow for transfer, so you can transfer the options, the units over to the outspouse, and so at that point they're divided and they can deal with it as they vest. Most of the time that can't happen. So what I see a lot is something written into the judgment that says when the stock options become exercisable, when they vested, notice needs to be given to the outspouse, and the outspouse needs to advise when they want their units to be exercised and sold and provided to them, or exercised and the units transferred to them. And that way the in-spouse has to participate and acknowledge it and follow those instructions. And so that's what we see oftentimes. Obviously with stock options, there's a vesting, there's an exercising. The RSUs just vest when they vest. There's no exercising necessary. So at the time that they vest and become available, that's when notice should be given to the outspouse, and they should make sure that some sort of transfer happens if possible. Sometimes there's restrictions.
Okay. Let's talk about tax issues in income as opposed to division of assets, different types of income and different type of income orders and how they are treated for tax purposes. And I think the basic thing to know that people are missing a lot is that even though spousal support is no longer taxable for federal purposes, it is taxable and deductible for state purposes. And I guess I'll ask Igor this. We haven't talked about state returns often, right? We have we've primarily talked about IRS and its enforcement, but I imagine that this can also happen on the state level, right?
Of course.
That something is not reported correctly. So I think most people assume that everything gets reported the same way on their federal return and their state return, but that's not always the case.
Yeah, there are some items that can be reported differently, and Jennifer probably can discuss them better than I do. From the enforcement perspective, yes, absolutely. Every tax agency here in the state of California will do their enforcement. If we're talking about audits of the income tax returns, the IRS, once the audit is completed, now it's just a matter of time and a matter of practice when the IRS will share its audit results with the California Franchise Tax Board, and they will follow the IRS determination and issue their own notices and will begin their own collection efforts. The FTB can do audits on their own, even without the IRS, and if the taxpayers underpay or owe tax liabilities to the state of California, the FTB will try to collect them. And I think, again, a practical point is that the state of California tax agencies are more aggressive in their collection efforts than the IRS, at least in my practice. That's what I see. And I think it's twofold. One is under the federal law, there are more procedural guidelines and protections for the taxpayer to work with the IRS and prevent them from forced collection action. For example, they cannot levy your bank account until they issue a certain notice, a final notice of intent to levy, which you can appeal administratively and try to resolve it. With the state of California, the Franchise Tax Board can pretty much start levying your bank accounts or wages as soon as they issue the bill and it's not paid. There are no collection due process rights. So you got to be very careful with that. You got to be mindful of that. And to the extent you have a limited pool of money that needs to be allocated, maybe sometimes the state tax agencies should take a priority over the IRS.
And I just wanted to just clarify one thing. You said that for state, the spousal support is still deductible. That is for California. So every state is going to be different.
Right.
You have to pay attention because sometimes the spouses have moved. So you have to pay attention to what state they live in.
Full disclosure, I'm only licensed in California.
So
Jennifer, how does the client, how do we not get in trouble with this, right? I guess, first of all, how do we make sure, and we know that this semester is used for temporary support and there is no really such thing as a guideline spousal support, but does this semester already take into account the California tax law when it comes to spousal support? And then what do we tell clients? Do we tell clients to tell their CPAs, make sure to report my spousal support order on the California return? Is it as simple as that? Is it more?
So DissoMaster is completely set to California settings. So it is automatically set to federal non-taxable, California taxable. In fact, if you have clients that are coming in for post modifications from prior to the change in tax law, you have to go into the settings and change it to make sure it's federally taxable. And from the other perspective, if you've got one spouse in California and one spouse out of California, you're going to need to go into the settings and make the modifications as well for the person who does not live in California. But as far as, telling their tax accountants, I would hope that their tax accountants are up to speed on the current tax laws. But yes, they would just need to notify them that they're going through a divorce and there's a spousal support order and what it is so that it makes sure it gets reported appropriately.
And one of the questions that came up in the chat is in California for spousal support, if the judgment says simply non-taxable to recipient, non-deductible to pay, or is that enforceable? I think what we try to do in our judgments is we try to specify it on the state and federal level. But I think it used to be, I don't remember anymore because it's been a few years, but I think the taxability had to be addressed in the judgment. Otherwise, it was ambiguous, right? We would state in our judgment under the prior law, taxable to recipient, deductible to pay or. What's the right way to do it now? Or is it the law by default, so to speak? It's going to be taxable in California unless the judgment states otherwise, or can the judgment even say it? Can the judgment do a carve out? Can people stipulate to a non-deductible support for the state purposes, I guess?
That's a great question. I believe they can stipulate to that, and I may be wrong, but it was my understanding that you can stipulate to make the spousal support non-taxable. That was my understanding, but the default is that for California, spousal support would be taxable.
Okay.
And I haven't seen this issue being, let's say, looked at or enforced by the IRS. I haven't seen this issue reason in any tax audit yet.
Good. And then also when it comes to calculating taxable versus non-taxable income, what about perks? I guess twofold question. We're running out of time a little bit, but I want to touch upon this. Igor, it happens to, this has baffled me since I started practicing family law. What people do for the purposes of their tax returns related to business expenses and what people do for the purposes of setting support and adding things back are two different things. And it has always baffled me that once Jennifer files her report with the court and says that 50% of my audit expenses are added back, I wish it was only 50%, and when that report comes into evidence and is relied upon by the judge, I'm not aware of any situation where the IRS then came in and said, aha, so it turns out that you did not report this properly on your taxes, and now there is an issue. Do you have any comment on this discrepancy, so to speak?
Yeah, no, I understand this discrepancy. I haven't seen the IRS kind of enforce or using this in their tax audits, at least with the expense side. I think probably that's where a great forensic accountant like Jennifer comes in, and I'm sorry, and deal with the issue and try to reconcile the two sides of it. I haven't seen the IRS kind of looking at the spousal support computations for the purposes of disallowing the expenses. I'll just very quickly mention, though, that from the standpoint of that whatever is filed in the family court is open, and the IRS is mindful of that. They are mining this data. I know some agents who go through family law records to identify certain issues. So they may not be very interested in Schedule C expenses, whether, let's say, someone deducted meals and entertainment expense a little bit more than they should have. But with respect to unreported income, any accounts, I had a case where the issue of an undisclosed foreign account was brought up in the family case, and then it had to be used in and then we had basically to do a voluntary disclosure to prevent the IRS from going after the taxpayer husband who previously did not disclose this information. So be mindful of that. The IRS can mine the family court data for future audits, although even probably not for very small issues.
And Jennifer, what's your take? I know there is this eternal debate depending on who you represent. When you add back perks, do you add them back as taxable or do you add them back as non-taxable? Why or why not?
My testimony on this, yes, I'm going to say it depends. But for the most part,
audience is your potential clients.
For the most part, perks are a non-taxable item, with the exception of if the attorney wants to argue Schultz. It's a legal argument, not an accountant's argument. It's not my argument to make. So for the most part, if we're going by what is actually happening on the tax return, perks would be a non-taxable event, barring certain things that are non-recurring, right? You had a one-time expense that's getting added back and it's personal, but it's never going to happen again. That's going to be a taxable add back. Retirement might be a taxable add back. But if Schultz wasn't there, perks are, the person has a habit of taking the same personal expenses year after year after year. That to me is a non-taxable add back. But again, it's not up to me what legal arguments the attorney wants to put forth. And if they're going to put forth Schultz, that's the argument that's going to be put forth. And so I have to make a note in my report saying the attorney is going to argue this. And that's why my report's reflecting this legal argument being put forth by the attorney. I will say to know your judge, because some judges, it's non-taxable all the time. Some judges are really all about Schultz. I've heard a lot in Orange County that a lot of the judges go automatically to taxable. So it's really knowing who your judge is.
All right. Okay, and the last item that I have is, this is happening in real time, so I just wonder if there are any best practices on this. What are people doing with PPP loans? Are we treating these as income? And if so, what is the taxability? I have taken a position a couple of times in the last few months successfully that until we know for a fact that it will be forgiven, we cannot count it as income. And then when someone asks me, well, what happens when it is forgiven? How are we going to know? I say, well, you can probably treat it as a one-off and perhaps treat it as a bonus income. I have been successfully able to argue it, but I know that there are different views.
Yeah, I mean, I think you just answered your own question. It is technically, PPP is technically a loan until it's forgiven. But even once it's forgiven, this is a one-time COVID relief, non-recurring event. So every company is going to have to be looked at individually. And was this COVID relief provided for the purposes of my business shut down for 2 months and this really helped cover that gap? And then with that in there, it looks like now I'm on par with the other years. Or, did we apply for this and we did it appropriately and we spent it on the right things, but, we may not have needed it. We got nervous in the very beginning and we weren't really sure. Is this just a one-time thing? I think we also have to consider the fact that there was other COVID relief. There was the EIDL loans, which were the 30-year loans, low interest rates. There was the $10,000 grant. So there was all these COVID relief things that were provided, which are all one-time events, but especially the EIDL, we have to then consider the fact that for the next 30 years, they have to make payments on it. So while we may not have an income item because it's a loan, they now have to make payments. And so that may reduce their business income going forward. So there's a lot to consider when it comes to all of the COVID relief. So there's no one specific way, but I think all the arguments you just said are completely valid, that it's a loan until it's forgiven. At that point, you really have to look at it and say, well, what really was going on with the business? And income available is supposed to be prospective. So if it's not going to happen again, you're really trying to look at a representative period to determine what's going to happen in the future. So it's really a one-time event.
And Igor, any idea how this is going to be treated or not yet?
Not yet. I think Jennifer is right. I think it's a loan until it's forgiven. I think Jennifer answered all the technical questions. Again, from my sinister standpoint of dealing with the government, we see a lot of action right now with the IRS and DOJ going after fraudulent use of PPP loans. So I guess in a divorce case, you got to be careful if you represent a spouse who is not in business, but the other spouse was in business and used PPP loans. Got to be careful, see that it's been used correctly.
Okay. I think we're out of time, but I'm going to ask one question from the chat for those of you who have asked questions and we have not been able to get to. I apologize, but you have Igor's contact information and Jennifer's contact information, so I'm sure they wouldn't mind. But the question that I am going to ask is something that goes back to filing separately. And the question is, my client, the out spouse, is a minimum wage earner and the other spouse is a high wage earner. Did I hear you say correctly that one? My client, the minimum wage earner, files her merit filing separately return. She will have to report half of the community income and what? Pay taxes on that? From where?
I think technically the short answer is yes. If they're filing merit filing separate, and if it's a community property, if there was no prenuptial or postnuptial changing that, then each spouse, if they decide to file merit filing separately, yes, then each spouse will have to report 1/2 of community income and be responsible to 1/2 of community assets. And two great lawyers should work out how this taxes should be paid.
But just remember, if, let's say, and I'm going to do the most simplistic, let's say the person is a W-2 high wage earner, they've had withholdings. The withholdings are also community. So tax payments have been made on behalf of the community, and the out spouse is going to also be able to claim those. Same with the estimated tax payments. If they're not a W-2 employee and they have to pay estimated, those are made quarterly. So it's likely, not always, it's likely that there's already tax withholdings that have been paid that out spouse will get to claim.
And in this case, an innocent spouse relief may be an option if one spouse is a low wage earner and she should be liable for her own share.
I guess that's the problem with the IRS, right? They always assume that people have the money that they do not have, right? All right. This is the end of our program. Thank you very much to all of you for listening. Again, there were a couple of questions that we could not get to just because of time, but Igor and Jennifer, I'm sure will be happy to try and answer them by email after the program. And I thank my co-panelists and the Beverly Hills Bar for putting this on. Thank you and good night.
Thank you. Thank you, Alex.